from a man facing charges of sexual assault of a...
And with the cause number ending in 6-4, the state is proceeding on the lesser included offense of aggravated sexual assault of a child. Range of punishment is anywhere from...
to another caught with drug possession despite his immigration status.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Here are 5 moments where Judge Boyd holds offenders accountable for their actions. Starting with the Mr. Martinez case. Here we have a man facing charges for sexually assaulting a child. It's outrageous how some can be so audacious to commit such a crime. Full trust in Judge Boyd. Let's watch how she'll handle this.
Mr. Rittenhour, is he only pleading to one case? Is he only pleading to one case? Is he only pleading to one case?
No, 2 cases, Judge. I thought you said count. There are 2 cases.
Is he pleading to both?
Yes, he is, Judge.
All right.
And we're going to ask for a PSI.
All right. Court is calling. No problem. Court is calling 2024 CR 4764 and 2024 CR 4765. State versus Luis Martinez. Can I have parties announced for the record for the state? Defense.
But written hour for the defense.
Are you Mr. Martinez? Counsel, have you received all discovery in each of the cause numbers?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, is there an application in either of these cases?
No.
All right. Mr. Martinez, in each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding with the indictment as presented and the cause number ending in 6-4?
6-4, no, we are not. We are waiving count 2 and proceeding on count 1 on the lesser included offense of aggravated sexual assault of a child.
That's our understanding, Judge.
Any objection?
No objection.
And are you proceeding with the indictment as presented in 6-5?
Yes, we are, Your Honor.
And each of the cause numbers, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. And with the cause number ending in 6-4, the state is proceeding on the lesser included offense of aggravated sexual assault of a child. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And cause number ending in 6-5, the state is proceeding on indecency with a child by sexual contact. That's a 2nd-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, Your Honor.
By entering this plea, you are giving up those rights. Did you understand that?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Martinez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of the cause numbers with your attorney? Did you understand it?
Yes, Your Honor.
All right. According to the plea, the cases are to run concurrently. There's to be Chapter 62 registration, and the cause number ending in 6-5. Punishments be assessed at 2 years in the prison, and cause number ending in 6-4. Punishments be assessed at a cap of 15 years. The state is proceeding on the lesser included offense of aggravated sexual assault of a child and count 1. There's a $1,500 fine in both cause numbers. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each of the cause numbers with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Do you understand?
All right, get went back.
All right. So here's the thing. Your attorney would have to file pretrial motions with the court. Sometimes those motions are, I want a witness list. I would make a ruling on whether or not he obtains a witness list. Or sometimes that motion could be, I don't want a specific witness saying something. It could be any type of motion. Do you understand that? All right, when you enter into a plea bargain agreement in these cause numbers, you are waiving or giving up your right to appeal. So you can't come back and say, you know what? I've changed my mind. You understand?
Speak
The
up.
only exception to that rule is if your attorney has filed some motions, I've ruled on them, and then you can appeal my ruling for those particular motions. Say, for example, if he filed a motion and he believed that he was entitled to something, and I said, no, you're not entitled to that. And you go to and you enter this plea. Well, you can still appeal because I didn't give him something he said he should have had. You understand? And that's just a hypothetical. Do you understand?
Yes, Your Honor.
All right. Outside the agreement, the state wants you to have no contact with the complainants. Do you understand that?
Yes.
Those are recommendations from the state. The court does not have to follow those recommendations. Do you understand?
Yes.
All right, then in cause number 2024 CR 4765, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2024 CR 4764, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers States Exhibit 1 and all attachments for both cause numbers.
We reviewed the documents and have no objection.
All right, did you review the documents entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty, and the court will also find you guilty, and I'm sorry, the court will also find you guilty in 2024 CR 4765. And my understanding, you're wishing to have a PSI?
That's correct, Your Honor.
All right, can I get a PSI date, please?
March 6th.
All right, we'll be back on March 6th. Do you need a TAP evaluation with that or no?
No, I don't.
Okay. All right. We'll see you back on March 6th, and I'll make a decision on whether or not I'll follow through with your plea bargain agreement.
PSI only, correct?
Yes. All right. Do y'all need to put something on the record for Mr. Nichols?
Yes, Your Honor.
Yes, the one thing outside the presence is a court.
Oh, does it need to be outside the presence? Because I'm not doing punishment. If we were to get there, it's the jury, unless y'all are changing your mind on election for punishment.
Unlike Mr. Martinez, this time we have Ms. Whitlock, who blatantly violated her probation and chose to return to drugs instead of turning her life around.
All right, court is calling 2024 CR 5014, State versus Waverly Whitlock. Can I have parties announce for the record for the state?
Megan Galloway for the state.
Orlando Castagnon for defense.
And are you Miss Whitlock?
Yes, Your Honor.
All right, Miss Whitlock, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Waverly Whitlock who was placed on deferred adjudication in 2024 CR 5014 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on June 25th, 2024 for a term of 2 years? Is that you?
Yes.
All right, state.
Your Honor, the state wishes to proceed on violation of condition number 4 in Bexar County, Texas. The defendant, Waverly Whitlock, did then and there fail to report to the supervision officer as directed for the months of July, August, and September of 2024 in violation of condition number
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is for the court to grant the state's motion, enter an adjudication of guilt against the defendant, revoke her community supervision, and sentence her to 90 days in the Bexar County Jail under 1244 of the Penal Code.
That is our agreement, Judge. She has a very little criminal history. The only history that I'm aware of is actually this case and a misdemeanor that she was also under probation for out of the same transaction. She was approved to move out of state to Arizona. and she had really nowhere else to go. She'd moved and left them. She's ready to move on out of Texas. She in fact was living in New Mexico, and that's where she wants to return to and reside. And so she asked that you grant that agreement and allow her to return to New Mexico.
All right, what has she done on probation?
I'm not quite sure as to the extent of what she's.
All right, do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Waverly Whitlock.
Just out of curiosity, usually they take jewelry. So is your ring attached to your finger or what's going on?
It's attached.
Oh, you can't remove it?
Can't.
Oh my gosh. So is it that it's too small or there's something that you did? Because I know now people are doing those things where you can't remove the jewelry. So is it one of those situations?
I gained weight.
Oh, okay. All right. So what have you done on probation?
I did attempt to call and check in.
When you say you attempted to call, what does that mean? Did you pick up the phone and call somebody?
Yes,
Who did you call?
I called the probation officer
Which probation officer? Was it Bear County? Was it in the other county?
and Bear County.
Okay. So how did you attempt to?
Other-
So where did you obtain the number to call?
I'm sorry.
Where did you obtain the number to call the probation officer in Bear County? So what else did you do? So you attempted to call. What else did you do?
That was it.
All right. So I don't
She
understand.
was hardly, I guess, on probation. I don't believe she was on
I
probation
didn't.
very long.
All right. So she hasn't done anything. I don't understand why I would give her 90 days, 1244. She hasn't done anything.
Well, so Judge, this would be a conviction on a record, and it would be something that it is a consequence of that decision. And so you're just asking that you allow her to accept that consequence and leave here in Texas.
All right. So the court will consider 1244, but I'm not considering 90 days for 1244. So if you all want to talk about that, you can. Does anyone know how many days does she have?
She has 90 days.
Oh,
jail time.
yeah, see.
Well, so I mean, it would be up to a year in Bear County Jail, Judge. So
This is what I will tell you, because you're telling the court that she doesn't have a record. This is a possession less than a gram. I will tell both parties, I will not go as high as a year. So if you all want to negotiate on a time, you can.
So Judge, our recommendation is 180 days for.
All right. Is that what you're in agreement to?
you okay with it? Okay. Yes, Judge.
All right. So my understanding, the parties have agreed to 180 days under 1244 at the Bear County Jail. Is that your understanding of the agreement?
Yes.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal? All right, let me explain something to you. With the 180 days at the Bear County Jail, some people are like, oh, I'm supposed to get 2 for 1 or 3 for 1. I'm not in charge of that. The only thing I'm in charge of is sentencing you. Whatever, if they want to give you 2 for 1 or 3 for 1, that's completely up to the jail. The only thing I can say is I'm sentencing you to 180 days and they can't go over 180-day sentence. Do you understand? Now, what I can tell you is I'm not going to pick up the phone and call the jail and say, I want this person to serve day for day time. You understand?
Yes.
All right. Miss Abrams, are you in agreement with revocation? All right. The court is finding violation of condition number 4 true. The court is going to grant the motion, find you guilty, revoke, sentence you to 180 days in the Bear County Jail under 1244. And let me just see if there's anything else that's due for your plea bargain agreement. All right. There is supposed to be money paid to Zachary Watson. Has that been paid? Was there any determination of a restitution amount?
Not that I'm aware of.
Probation, any determination of a restitution amount for Zachary Watson? State, I'm assuming that was something that was taken in consideration.
Yes, Judge. So she had a misdemeanor burglary of a vehicle that she was also revoked on, and I believe that it was a condition in that case mirrored in this case.
All right, so the question becomes, have you paid anything to Zachary Watson?
No.
I'm going to put in here restitution, if any, to Zachary Watson. Is there any objection?
No, Judge.
All right. And the reason why I'm including that is because that was a part of your plea bargain agreement. So restitution, if any, to Zachary Tompkins Watson and cause number 729-266. All right. Is there anything else from either side with regards to sentencing?
Not from the state, Your Honor.
Nothing from defense.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. It appears that you may have drug problems. Don't visit those drug issues on your mom. You need to make sure that you get into sober support meetings. That's what they call the NAAA meetings now. Or if you need inpatient treatment, there are plenty of places that are free. If you can't find a place that's free and you need the help and you want the help, you can always come back here. I will, use whatever contacts I have in here to reach somebody in Mexico or Arizona or wherever you may be. But if you don't get a handle on this and control this, you're going to be picking up more and more cases, and you're going to look up and a majority of your life is going to be passed you by, and it's going to be in a haze. Because how you've been liking the Bexar County Jail. Yeah. So you got to remember that. Okay. All right. Good luck to you.
Thank you, Judge.
Thank you.
You're welcome.
Still on offenders facing charges for possession of drugs, this time we have Ms. Drummond facing the consequences for abusing hard drugs like heroin and meth daily. Let's watch how Judge handles this.
All right. And for the state,
Jason Garahan, you're outside of mine.
for the defense,
Oh, Bob Hicks.
and are you Amanda Drummond? All right. You entered a plea bargain agreement. And according to the plea bargain agreement, the state is recommending deferred adjudication. You're charged with possession of a controlled substance penalty group 1 gram to 4 grams. The court ordered a TAP evaluation before sentencing based upon what I reviewed in the stipulations. Have both parties had a chance to review the TAP evaluation state?
Yes, sir.
Defense?
Yes, Your Honor.
Any objections to the TAP evaluation?
Nothing from the state law.
Nothing from the defendant.
All right.
She seems to be highly motivated for treatment.
All right. Anything you wish to say on behalf of your client?
Well, Judge, according to the TAP evaluation and the Tacoma evaluation, she has had a pretty rough life, part of which is occasioned by her drug problems.
Mhm.
And part of which is the fact that her family has basically disowned her.
All right.
She
And I'm
has
sorry,
had-
just one moment. And state you may be excused.
Thank you, Judge.
All right. You may continue.
She has a friend who is pretty much her sole support.
Mhm.
And she, as it says in the TAP evaluation, is very high. She wants treatment. She knows she's not going to be able to kick this stuff on her own, especially given what she was using, which was heroin daily, meth daily, and a phenomenal amount of alcohol daily. And the materials provided indicate that she is recommended for treatment, and she is eager to take that treatment.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. State your name for the record. All right. Make sure you keep your voice up so that the court reporter can hear. All right. So do you have any children?
I do, but they're all grown.
All right. You're not going to be released today because what I'm going to order is, Miss Abrams, I'm unaware. I don't know if felony drug court has started openings or no. All right. All right. So this is what I'm going to do because one, the reason why I ordered the TAP evaluation is I want you to be successful in this probation. And I see that there are some drug issues that are happening. So we want to make sure that you have all the tools you need to be successful. In this courtroom, to be successful on probation, communication is key. If you ever feel as though you want to use or life is just hitting you and knocking you down, you can pick up the phone and call your probation officer and tell them, hey, I think I'm going to use. This is what's happening in my life. They're not going to send me a violation report saying revoke her. All violation reports come to me. And sometimes I will have compliance hearings where I have people come in to say, hey, what's going on? So I can hopefully get you back on track. And of course, there are some things that I can't get you back on track. If somebody picks up maybe a violent offense, I keep an open mind about everything. But for that, maybe I'm just going to sign a motion and say, hey, motion to revoke. But if there's an issue with your drug use, which is what we're trying to address, you got to do your part and we'll do our part. Okay. So what I'm going to do, Miss Abrams, in this case, I'm going to place her on probation, 6 years deferred adjudication. Here's the thing about that 6 years deferred adjudication. If you complete everything early and you're doing great, the probation will send me a notice saying, hey, can you let her off probation early? She's got everything under control. She's doing great. And if that's the case, then I'll probably let you off early. You understand? So even though I'm saying 6 years deferred adjudication, whether you're on for 6 years or not is completely in your control. There's going to be regular reporting by Zoom or in person. That means you have to report. And usually it's once a month. All right. If you need to report more than that because you're trying to stay on track with your sobriety, just let probation know. They'll make adjustments. Okay. There's going to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. So you can get a job, but not as a babysitter, or you can't babysit. You can't work as a home health care provider. Okay. There's going to be regular random UAs, and the UAs is where they test you for drug use. Okay. I'm going to want field visits one time per month until further notice. Now, Felony Drug Court is a great program. They're not going to be available to even consider accepting you till the beginning of February because of funding. I always tell everybody, talk to your legislature about getting them funding. So, Ms. Abrams, we're going to do a referral to Felony Drug Court, and then I'm going to follow the recommendations of TAP evaluation. I want Felony Drug Court first because they'll be able to address the drug issues plus the mental health issues. But we can also do a referral to DDRF, which is what they're recommending. If for some reason she's not accepted into that and she can't get into Felony Drug Court, we'll bring her back and we'll consider another placement for you. Okay. I just don't want you out in the world with not any support. I'm going to want 120 sober meetings and 120 days upon release. And let me just see if there was anything else that was asked in your plea bargain agreement. All right. Probation. Is there any, there's going to be 200 hours of community service restitution. Do you have any grandchildren?
I have,
And what's their age?
she's 2.
All right. And are you in contact with your family?
I have contact with them.
All right. So let me just tell you, sometimes people want people to babysit. You're not in the condition yet to be babysitting, right? But what I will do is I'll deduct 100 hours of your community service restitution. And I'm going to order that you complete parenting classes. That's to help you when you are clean and sober and you want to be around your grandchildren. How far did you go in school?
10th grade.
All right. And then I'll do another 100 hours if you obtain your GED or some sort of trade school certificate. So I believe that community service hours, sometimes helping the community, is you getting your GED, you getting good, stable employment. So you need to complete your parenting classes. I'll deduct 100 hours off of that. And probation. If she obtains her GED or trade school, that'll be another 100 hours. If you don't want to obtain your GED or in some sort of trade school, then you're going to have to do 100 hours of community service. And sometimes that means picking up trash off the highways and byways. You understand? Yes.
I've been to a trade school. I have my CDL.
Okay.
So, I mean, I've already been to trade school before.
All right. Well, I tell you what, if your license is in order and you present that to probation, then I will deduct 100 hours of community service restitution.
Okay.
All right. Probation, is there anything else? I'm sorry, what? Yes. And MIC supervision. And that's a specialized caseload so they can address any issues you have. Anything else, probation? Is there anything else you need from the court in order to be successful? Yes.
I apologize. Mr. Hicks mentioned that she lived in Karnes County.
She lives in Karnes County. However, she understands that she's going to need to live here until.
All right. So are you okay with living in Bexar County? All right. So she's okay with living in Bexar County. All right. So counsel, I need your client to sign the trial court certification of defendant's rights to appeal.
I didn't do this before. And there, where it says defendant. I got you there.
Right here.
Yes.
Thank you.
That
All right.
explains why I didn't sign any of those before. Actually, I did. I have one.
All right. Did you review the document with your attorney? It's called Trial Court Certification of Defendant's Rights to Appeal. It's this document
Yes.
that you just signed.
Yes, ma'am.
Did you review that with him?
Yes.
Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. We can go off the record. In this court, as I said before, communication is key. If there is an issue, let your probation officer know. If you feel that they're not addressing it, if the courthouse is open, I'll be here. You can come in and address it with me, okay? All right, if you need anything, let us know, all right? You're welcome. Probation is going to go over conditions with you. Thank you,
Thank
Mr.
you.
Hicks.
How many chances should offenders like this get? Unlike Ms. Drummond's case, Ms. Pryor here is facing charges of drug abuse down to her homeless condition.
All right, so on this case, let me see what I have here.
Yes, Your Honor. This is the one with yes, y'all recommendation for Europe. It's essentially been
Hasn't looked at it yet.
Okay. So what happened with because I ordered the felony drug court, I know they're full.
Yes, Your Honor.
They won't have room until the beginning of February.
Yes, Judge.
If you all want, we can wait on that. I don't know if the MIC evaluation has been completed.
It has, Your Honor. That's correct. The recommendation from community supervision is DDRF, Judge.
Okay.
Ms. Zapata notified me that it's about a 2 to 8 week wait on average. Last time we were in court, I did seek some alternatives to possible extended DDRF stay, Judge. She suffers from substance use disorder and she was interviewed by PICU and she met criteria for paid for it at Haven for Hope, Judge. I know I spoke with Bashan about it last time and she had a concern of whether people with mental health issues can in fact participate at paid for it. And I followed up and they stated that they could accommodate her, Judge. Our concern is that she has housing issues too. So we feel that the paid forward program at Haven for Hope can address her substance use, get her coordinated with Haven and possibly move up within Haven to get stable housing, Judge. We don't, and I know the court's concern is they don't want her released to the community where she doesn't have the resources, reoffend and MTRs triggered. Ms. Pryor has been in custody. We're waiting us to meet here in court, Judge, and we were just asking respectfully if she could be considered for paid forward. I did get confirmation yesterday that she does meet criteria, and I did forward that to the court as well as representative from the prosecutor's office.
All right, are you currently on your medications?
Yes, ma'am.
All right, do you have a phone or the ability to call someone once you're released?
Yes, ma'am.
All right, so this is what probation
Yes.
with her, this is what I'll require. We're going to see if pay it forward at Haven is going to work. So I'm going to require that she call into probation upon release. You're going to call into probation once every 2 weeks.
Yes.
Because the concern I have, what I usually find at Haven for Hope, when persons have a combination of that plus mental health, they end up falling off the radar and probation can't get in touch with them. So you're going to have to call them once every 2 weeks to say, here I am, right? And that's going to be in addition to her reporting. If you all want her calling to you once every 2 weeks as her reporting, the court is fine with that. Just as long as you all make sure she is still in the Pay It Forward program at Haven for Hope.
We don't do the phone recording anymore, but what I'll just notate is if possible, we can always facilitate like a Zoom meeting or something to that effect. And I think Pay It Forward has been pretty amenable to making accommodations for that.
Okay. Is there anything else you need?
No, ma'am, none at this time. Thank you for the opportunity.
Oh, you're welcome. So your attorney will tell you in this court, people are placed on probation. I'm hoping they're going to be successful. If I didn't think you could be successful, I wouldn't have gone through with your agreement. So communication for you is going to be very important. Communication with your doctors, with your probation officers. If something happens and you feel you can't get in touch with probation, you can always come back in here. You can always call your attorney and we'll see what's going on.
I have one question.
Sure.
After this is completed during this process, I've lost my home. So Pay It Forward's gonna be helping with that situation.
Yes.
But if after I complete this program and things like that, to transfer my probation to another county because I've lost my home, would that be something I need to come back to you to or
Yes.
to?
What will end up happening is once you're stabilized in the community, probation will send me a request for you to transfer to another county.
Okay.
But I don't just send people to other counties unless they have stable housing and everything else.
Right, I understand that.
Yes.
And Judge, Ms. Pryor was awaiting a final Tacoma evaluation in custody on January 28th. Would you like us to continue with that on bond?
Yes.
Okay, That way we can cancel it and then I'll just have them set up a new appointment for her.
All right, so you'll probably be released at midnight. That's what they do. Why? I don't know. I have no control over that, but
Your Honor, with regard to that, PICU did notify me that if the court did allow her to do paid forward, to get with them to coordinate a release plan, Judge. So I can go ahead and notify them that Your Honor graciously allowed her to do the program to better her life, and then ask that maybe not a midnight release, but something more during daytime hours, because I know that they're gonna need to transfer her directly from custody to that paid forward and follow all the rules and regulations there.
yes.
Sure, I'll go ahead and
Okay,
do that.
all right, thank you.
Thank you, Your Honor. Maybe excuse
You're welcome.
And finally, this last case focuses on Mr. Delgado, who is facing charges of possession of drugs.
All right, the court is calling 2024 CR 010699, State versus Guadalupe Romero Delgado. Can I have parties announced for the record for the state?
Albert Chidas for Mr. Delgado.
And are you Mr. Delgado?
Yes.
All right, we have an interpreter. Hi. Could you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Sachs.
All right. And counsel, do you speak Spanish?
I do, Your Honor.
Do you speak it fluently?
Yes,
And have you been able to communicate with your client in Spanish?
I have.
And have you explained all these documents to him in Spanish?
I have.
Mr. Delgado, all of the documents that I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
Counsel, have you received all the discovery? Did you review it with your client?
I did, and I have.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
They're not, Your Honor.
Mr. Delgado, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Delgado, did you review the court admonishments with your attorney? Did you understand it?
Yes.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
All right, off the record for a moment. The plea bargain page isn't filled out completely. Mr. Delgado, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No. No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No. No.
Counsel, did you confer with your client and explain to him the impact a guilty verdict or plea in this case will have on his immigration status?
Yes, I did, Your Honor. I also had Matt come in just to also consult, but yes, we did. And he's aware of the consequences.
All right, Mr. Delgado, did you have a chance to confer with an immigration attorney about the impact a plea in this case would have on your immigration status?
Yes.
Did you understand that a plea in this case could result in your being deported?
Yes.
That you could be denied re-entry into the United States,
Yes.
and that you could be denied naturalization.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes. Yes.
According to the plea, you're to be sentenced to 1 day in the Bear County Jail under 1244. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No me opongo. No contest.
State any evidence.
No
objection, Your Honor.
Did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, what is happening with the DWI?
That has already been resolved. I don't even think that.
And Mr. Delgado, are you here legally?
It has been resolved. No. Legal, I'm sorry.
Legally.
No. No. He's not. The DWI has been resolved and he's not here legally.
All right.
Yes.
All right, so I'm assuming this 1 day in jail is the judgment satisfied?
Yes, Your Honor.
Correct, Your Honor.
Why am I giving him 1 day in jail, a judgment satisfied?
Because that's the deal.
All right, do y'all want to confer on the amount of time? Because I don't think 1 day is sufficient. I will still do a 1244 for him.
I don't believe that we believe that 1 day is appropriate.
I don't believe 1 day is appropriate.
That's fair.
Okay. And we can go off the record.
That's pretty much what I got for you guys on this one. Hopefully you enjoyed the video. If you did, make sure to leave a like and subscribe to the channel. Thanks for watching, and I'll see you on the next one.